Bismillahirrahmanirrahim. We are again here, and in this sitting, we will discuss the lecture 7, part 3, which is related to customary rules of international law and right of self-defense against actual attack and attack by terrorists and anticipatory self-defense. And in this sitting, in this vlog, we will start from the right of anticipatory self-defense. Anticipatory self-defense means the right to anticipate, which means where there is no actual attack, but the preparation of attack at the other end, and the second end would retaliate to that attack, which called anticipatory right of self-defense. The right of anticipatory self-defense is not recognized by international law. This is still debatable issue, and for this right there would be a imminent danger of attack. Where there is no imminent danger of attack, there should not be right of self-defense. Anticipatory self-defense can be used or utilized. But in 1981, Israel attacked a closed nuclear reactor of Iraq by sending F-16, 6 F-16. Those attacked the Iraq under this right. But the same was not recognized by the international community and the global world. It was viewed, it was observed that there was no actual or imminent danger to the security of Israel. Hence, the attack was not recognized or supported or endorsed. Criticism to the theory of self-defense. According to Professor Koitle, this theory would open the floodgate regarding wars, and it belongs to a tank division. It is not a wise theory, it is not a recognized theory, it is not a established theory, but it would open worldly wars. And Brownlee well said, to commit a state to an actual conflict when there is only a circumstantial evidence of impending attack would be to act in a manner which discarded the requirement of proportionality. In international law, right of self-defense is recognized, but the principle of use of force in a proportionate manner is also established principle. But under this anticipatory self-defense, the principle of proportionate is missing because there is no actual attack, and anticipatory self-defense is aggressive, and that is a retaliation without any attack. Self-defense against terrorism. Again, this issue is debatable and still has not resolved. Self-defense against terrorism. If the attack is made by a country and not by a non-state actor, then the right is recognized. But if the individual group, the non-state actor, has attacked, then the country should not be blamed or alleged. But the America, after 9/11, through its Congress, passed resolution in which it was declared that the country who was supporting, sending or harboring the terrorists, the attack should also be made on that country. But the principle is still not recognized by international community and under international law. Important cases about this anticipatory self-defense and right of self-defense and the terrorist attacks. Nicaragua versus US case 1986. In this case, it was held an armed attack must be understood as including not merely actions by regular armed forces across an international border, but also the sending by or on behalf of a state of armed bands, groups, irregulars or mercenaries, which carry out acts of armed forces against another state of such gravity as to mount to an actual armed attack conducted by regular forces or its substantial involvement therein. Uh, the second case is Eichman case. In this case, Eichman committed genocide of Israelis and hid in Argentina. Israel forces picked him from Argentina without taking into account the concerned country. The act of Israel was declared against Article 2.4 of UN Charter. Uh, Again, this is the genocide was committed. The crime of genocide was there, but the Israel overreacted, and the use of force and the interference in other states' right was not recognized because the Argentina was not the alleged country and was not supporting those who had committed the genocide. Corfu Channel case. In Corfu Channel case, two principles of anticipatory self-defense was recognized. That were the history of this case. In this case, it was held that the Britain's use of force in Albania without its permission was illegal, and essential elements to consider a terrorist attack as an armed attack under the purview of Article 51 are two. First one is the attribution. This means the terrorist must be either state organs, state terrorism, or acted on behalf of the state sponsored terrorism. Two things to anticipatory self defense regarding terrorist attack on a state. There should be a two. One, the state has supported or the state has sponsored. Otherwise, the state is not responsible. Scale of effect. The scale and effects were the attack must be of such gravity as to mount to an actual armed attack conducted by regular forces. To answer a terrorist attack and to attack on other country, along with attribution, the other is the scale and effect. The scale should be of that large, which amounts to or tantamounts to a actual armed attack. And in the end, it is concluded that the in this the issue regarding anticipatory self-defense and the self-defense against terrorist attack is a still debatable issue, and the Britain, America, and Israel has used this right, but the other community condemned, and the International Court of Justice also condemned the Israeli act regarding anticipatory self-defense in 1981. Thank you very much.